Welcome to the deep dive. We are taking a deep breath today and tackling a big stack of complex legal sources. We've got the monumental Digest of Justinian,
Quite the read.
definitely, and alongside that, the fiery rhetoric of ancient Greek oratory. We're aiming to give you the essential knowledge about what really made the ancient world tick.
Yeah, because when most people think of Roman law, what comes to mind is usually the big public spectacle, right? Cicero defending someone on a capital charge.
Or those dramatic criminal trials deciding the fate of the Republic. Big stuff.
Exactly. And look, that high drama, it was certainly important, no question. But if you really dig into where the legal system spent most of its time, where it generated the most, frankly, complicated legislation and the most persistent, bitter conflicts.
Wasn't always the murder trials.
Not at all. It was in the extremely messy, high-stakes world of family disputes, property ownership, and maybe above all, the truly labyrinthine rules governing inheritance.
That's really our focus today, then, moving past the political flash.
That's the plan. We want to synthesize a mosaic of ancient practices, show how Romans, and Greeks too, structured kinship, how they managed property transfer, and, this is critical, how they litigated, often with real ferocity, when those systems inevitably broke down or came into conflict.
So this dive is going to blend Roman legal concepts straight from sources like the Digest with, say, Athenian rhetorical contexts.
Right. To reveal this enduring, sometimes really painful obsession they had with getting wealth transfer right and resolving the conflicts that came with it.
Okay, and we probably need to start by setting the stage, maybe highlight a fundamental difference in legal culture straight off the bat. Looking at litigation in Athens, through Demosthenes or Lysias, conflict often seems incredibly personal.
Oh, absolutely. It's often framed fundamentally as just pure enmity, a feud.
That's a huge difference.
It is. I mean, think about the Athenian litigant Ariston. This is Demosthenes 54. He gets physically attacked, right?
Yeah.
And he has to argue, at exhaustive length, that the fight was actually serious enough to even warrant bringing it to court.
He's arguing about whether it's worth the court's time.
Pretty much. He's essentially anticipating a defense that the whole issue was de minimis, too trivial for the courts.
So Ariston's challenge wasn't just, did this guy hit me? It was proving that the action was a big enough violation of community honor to justify taking up the court's time.
Exactly that. And it tells you something fascinating about Athenian society, right? These competing, often conflicting values. On one hand, yeah, you had recourse to legal redress. But on the other, there was this deeply ingrained social expectation.
That you just handle some things yourself.
Or just shrug it off.
Yeah.
That certain, maybe low-level violence or indignities should be settled privately. For every person rushing to court after being shoved, there were probably others thinking, come on, the court shouldn't be an outlet for every little personal slight.
Okay, but then we pivot sharply to Rome. And the system just feels different immediately.
Totally different vibe.
The rules for establishing who's related to whom, how property moves, how disputes get resolved, it all seems so much more formalized, rigid even, super detailed.
Mm-hmm. The legal structure itself is the core mechanism. It's this massive attempt to impose order on what could otherwise be, total familial chaos.
Right. So let's jump into that Roman structure then. Okay, let's unpack this. This foundational Roman obsession with lineage, which, as you say, fundamentally dictates how property moves. We're talking about agnation.
Agnation, yeah.
This isn't just sociology, is it? It's like the legal DNA of early Roman wealth transfer.
That's a good way to put it. Agnation is the strict definition of kinship traced exclusively through males. Only the male line counts for legal kinship. And early Roman law was incredibly deliberate about establishing this.
How so?
Well, it meticulously purged itself of the older, broader concept of cognation. Cognation recognized kinship tracing through females as well, you see.
Yeah.
But Rome pushed that aside. Agnation became the fundamental, the natural form of kinship in their earliest legal system.
Why? Why was it so vital for them to define kinship so narrowly? Was it purely about controlling property, or was there something else? Politics? Military reasons?
It was primarily about establishing clear, predictable lines of succession and authority. And that was absolutely essential in a highly patriarchal society, one built on military needs and agricultural foundations.
Okay.
By focusing exclusively on the male line, you maintain this single, unbroken chain of authority, and it all culminates in the paterfamilias.
The head of the family.
Right. And what's truly remarkable, almost startling, is how sticky this legal concept proved to be. how long it lasted.
Okay, tell us about that persistence. How did these seemingly ancient, almost purged Roman ideas manage to influence legal systems centuries and centuries later?
The influence is profound,
Yeah.
often in ways that are subtle or even misunderstood later on. For example, the historical exclusion of females from certain governmental functions, like ruling a kingdom.
Yeah, often attributed to the Salian Franks, right?
Usually, yes. But its much deeper, more fundamental origin actually lies in this Roman agnatic way of thinking. The principle was already there.
Wow. Okay. But you mentioned an even more stunning example, something about half-blood relatives in English law.
Ah, yes. This sounds like a really obscure legal point, I know. But bear with me, because it shows the dangerous permanence of misunderstood legal history. It's almost the purest example of misapplication you could find.
Intriguing. What was the rule?
We're talking about the now repealed English law that prohibited brothers of the half-blood from inheriting each other's lands.
Okay.
Seems harsh.
It was. But if you trace the origins of this rule back to its roots, it applies correctly only to what are called uterine brothers. Meaning they share the same mother but have different fathers. So crucially, they share no agnatic link whatsoever, no connection through the male line.
Got it. So the original Roman or Norman logic based on agnation was, if you don't share the crucial male lineage, the father, you can't be legal kin for inheriting land. Precisely. Makes sense within that agnatic framework.
Yeah.
However, when this principle got transplanted, probably from the customs of Normandy over to England, the English judges completely misinterpreted its scope.
How?
They extended it to exclude all half-siblings from inheriting land from each other.
Okay.
That included consanguineous brothers,
Consanguineous, meaning?
sharing the same father but having different mothers. Now, in the original Roman or Norman agnatic context, the consanguineous brothers should absolutely have been eligible to inherit. Why? Because the crucial male link, the father, was preserved.
So wait, a misunderstanding of one kind of niche legal technicality led to potentially centuries of incorrect inheritance rulings in England.
Pretty much, yes. It became an absolute nightmare. It forced brilliant legal minds like Sir William Blackstone, the famous commentator,
Of course.
to invent pages and pages of elaborate, convoluted sophistry, just trying to justify this utterly irrational exclusion of the half-blood. They had to build this whole intellectual superstructure.
Just to prop up a rule whose original simple agnatic principle had been completely lost or misapplied.
Exactly. It's a powerful lesson, isn't it? How historical error can become enshrined as actual law, defended for centuries.
That's a staggering amount of intellectual effort just to justify a mistake. Wow.
Yeah.
Okay, let's bring it back to the Roman family itself. The all-agnatic structure, you said, centered on this formidable figure, the paterfamilias.
Yes, the paterfamilias. And he was much more than just a figurehead or, the man of the house. Legally, he was the visible steward, the administrator of a common family fund, a shared economic resource.
So the family was almost like a corporation?
In a way, yes. Early Roman law really saw the family primarily as an economic unit, a corporation almost, held together by this single administrator. This established an incredibly close, stringent, binding economic connection within that family unit, far tighter than later ideas of just parental authority.
Okay. But even that tightly controlled agnatic system, it didn't last forever, right?
Yeah.
It eventually began to crack, leading to these significant shifts in Europe. Notably, the rise of primogeniture.
Right, succession by the eldest son.
Was this seen as progress, a sign of improved legal thinking?
Well, interestingly, many legal historians actually view this shift not as progress, but as a kind of societal retrograde moment, a step backward in some ways.
Really? Why?
This shift towards primogeniture gained massive momentum during the dissolution of the Carlovingian Empire.
Yeah.
Think around the 9th, 10th centuries, what was happening then. Centralized civil authority, the power of king, the state, it became incredibly weak, feeble.
Chaos, basically.
Pretty much. And in that vacuum, men spontaneously recurred to this highly archaic, very family-centered system of succession, primogeniture.
So when the state failed to provide cohesion or security, society fell back on the simplest, maybe most primitive rule of succession, just for survival.
Precisely. They needed simple, indisputable rules, especially for a new kind of property that was emerging at the time, the benefices. They were conditional grants of land, often tied to military service.
Oh, okay.
Primogeniture ensured that a property, a source of military power, remained intact, controlled by the single most capable military successor, usually the eldest son. It helps consolidate power locally when the larger civil society couldn't.
And this reliance on personal ties to the land, established through succession rules like primogeniture, that laid the groundwork for feudalism,
Absolutely essential groundwork, yes.
which then eventually gave us the idea of territorial sovereignty.
Exactly. That deep connection we now take for granted between political power and the ownership of a specific piece of land that was actually a relatively tardy offshoot of feudalism. Feudalism was really the first system in Europe to formally and legally link personal duties, rights, allegiances directly to the ownership of a specific, limited chunk of land.
So it codified the idea that your personal allegiance, your political power, it stems entirely from where you stand on the earth.
Right. Completing that transition away from the older, purely personal status defined by agnation, land became the key. Okay, so if Section 1 laid out the sort of foundational structure of kinship and property, Section 2 really shows the incredible legal ingenuity the Romans needed to manage the consequences of that structure, especially when it came to wills.
This is where it gets really complicated, I imagine.
Oh yeah. What's fascinating here is how Roman law created these incredibly detailed, almost surgical mechanisms to manage bequests. They try to anticipate virtually every possible scenario. Why? To protect the testator's intent, sure, but also, crucially, to protect the heir's status and ensure the will actually functioned.
Sounds like it kept the jurists very busy. An entire cottage industry, maybe.
You could say that. Let's start with the difficulty of conditional institutions, making a bequest dependent on some future action or event. When did the law step in and say, nope, we're overriding the testator's condition?
Good question.
Conditional institutions were a total minefield, but the law generally intervened to override conditions that were seen as being against, well, sound morals or basic decency. The digest gives a specific example.
That's wet.
Okay, so if a testator made someone an heir on the condition, say, if he has not redeemed his father from captivity, or if he has not provided maintenance for his parents, the law would just disregard that condition. Poof, gone.
Really?
Yeah, the institution of the heir would stand. It was treated as if the condition was never written in the first place.
So the law is establishing a clear priority here. Basic pietas, family duty, trumps the deceased person's maybe spiteful or eccentric demands.
Exactly. But then what about the flip side? The disinherited son. Roman law, as we said, was obsessed with ensuring the family line continued, the patrimony passed on.
Right, so how did they handle disinheritance?
Well, they explored this concept of conditional disinheritance, and the key was intent. If a son was disinherited without malice, say, because the testator was demonstrably insane when writing the will, or because the son was an impubes, a minor below puberty, and maybe there was a misunderstanding.
So accidental disinheritance, almost.
Sort of. The law recognized that potential. He wasn't necessarily prejudiced just because the will said he was disinherited in those cases.
And how did they fix that? How did they ensure fairness if the will itself was legally valid but maybe morally wrong?
Often, the solution was that the person who was instituted as heir was recruited, sometimes quite strongly, to restore the estate, or part of it, to the excluded son. This happened through a mechanism called a fideicommisum.
A trust, basically.
Essentially, yes,
Oh.
a trust. It was a clever way for the law to mandate compliance with what was seen as a moral obligation. It corrected accidental harshness while still formally respecting the legal structures of the will itself. The son could be technically disinherited according to the letter of the will, but the fideicommisum ensured equity was maintained down the line.
Very Roman. Okay, we also have those specific, tricky rules governing freedmen. They were free citizens, but still legally tied to their former master, the patron. How did that dynamic mess with inheritance?
Oh, it created this really complex three-way interaction you had to navigate. You had the testator, the freedman writing the will. You had the heir, often the freedman's own son. And then you had the patron, looming in the background.
Always the patron.
Always. So let's say a freedman conditionally institutes his own emancipated son as his heir. But then that condition fails. Maybe the son dies before the condition is met or doesn't fulfill it. Normally, a substitute heir named in the will would step in.
Right.
But the patron's right to bonorum possessio, basically, the right to possess the goods of the freedman's estate, if the freedman died without suitable heirs, that right was protected. It often took precedence over the substitute heir named in the will. The law had to respect the patron's lingering legal claim on the freedman's estate, which seriously complicated the normal lines of substitution.
Wow, okay. Layers upon layers. Now, let's get to what is arguably the most famous piece of Roman inheritance legislation ever, the Lex Falcidia. Why was this statute, the one guaranteeing the heir a quarter of the estate, why was it so fundamental, so crucial to the whole Roman system of wills?
The lex falsitia. Passed in 40 BC, it was pure, unadulterated legal pragmatism. It guaranteed the primary heir, the heirs, a minimum of 1/4 the quarta falsitia of the net estate, free and clear.
Why? What problem was it solving?
The issue was that wealthy Romans, often eager for posthumous glory or wanting to reward lots of friends and dependents, would burden their heirs with so many specific legacies, gifts of money, property, whatever, that accepting the inheritance actually became a financial liability for the heir.
You mean the debts and the legacies added up to more than the assets the heir actually received?
Exactly. If the liabilities clearly outweigh the assets coming to the heir personally, what would the heir do?
They'd just say, no thanks, renounce the inheritance.
Precisely. And here's the kicker. If the primary heir renounced, the entire will failed. All those specific legacies the testator wanted to give out, poof, gone. The legatees got absolutely nothing because the inheritance was never formally accepted in the first place.
Ah, okay. I see the problem.
So, by guaranteeing the heir this inviolable 1/4, the lex falsitia ensured that the heir would almost always have a positive financial incentive to accept the inheritance,
Which then validates the will.
and guarantees that all the other legatees would at least get their share of the remaining 3/4, or whatever was left after debts. It was a brilliant statute, really. Designed less for the heir's benefit, ultimately, and more to protect the system itself, to make sure wills actually worked.
So the law was ensuring the 75% got distributed by essentially forcing the heir to take the 25%. Clever.
Yeah.
Kept the wheels turning. But how on earth did they value this quarter? I can just imagine the legal battles over valuation.
Oh, intense. The rule was the patrimony, the estate, was valued at the precise moment of the testator's death. Not before, not after. The timing was absolutely critical.
Why? What difference does the exact moment make?
Think about accretion. Any increase in the estate's value that happened after the testator died, say slaves having children, farm animals giving birth, investments increasing in value, none of that counted towards the heir's guaranteed quarter.
Okay.
The quarter was calculated based on the snapshot value at death. And if the total value of the legacies initially bequeathed in the will exceeded 3/4 of that snapshot value,
They had to be reduced.
automatically.
Yeah.
Every single legacy was reduced proportionally across the board until the heir's quarta falsitia was secured. No ifs, ands, or buts.
Mathematically complex enough, but then you throw in the problem of conditional debts or legacies, money owed to the estate maybe, but only if some uncertain future event happens. How did they calculate the estate's value then when some assets were totally uncertain?
Right. This is where Roman legal precision, or maybe complexity, really reached its zenith. They used this ingenious system involving cautio, giving and taking security, basically.
How did that work?
Okay, imagine the testator dies. The estate is owed a huge sum of money, let's say. But it's only owed if a lawsuit, currently pending, goes in favor of the deceased's business partner. That might take years to resolve. The debt is conditional.
And that massive uncertainty makes valuing the estate now pretty much impossible for the lex faltitia calculation.
Exactly. So the solution involved mutual undertakings, formal promises, between the heirs and the legatees. They would essentially agree on how to treat the conditional item for now.
Okay.
If they all agreed, say, to treat that uncertain debt as if it were unconditional right now, to maximize the pot for legacies, then the legatees would have to provide security cautio to the heir. They'd promise to restore the proportionate value of their legacy later if the condition ultimately failed, if the lawsuit was lost and the money never came in.
And the other way around.
Conversely, if they agreed to treat the conditional debt as non-existent for now, maybe to ensure the heir's quarter was safe, then the heir would have to provide cautio to restore part of the inheritance if the condition later succeeded and that uncertain money actually did come into the estate.
Wow. It's like a system of formalized bets and guarantees just to allow the estate distribution to proceed immediately, despite future uncertainty.
That's a great way to describe it. It required immense trust, or at least incredibly detailed legal documentation and security arrangements.
Okay, shifting gears slightly from abstract money to physical property. The Romans were just as meticulous, weren't they, about defining physical legacies? You mentioned the fundus instructus, the bequest of a fully equipped farm or house. What kind of detail did that involve?
This is where the judge practically had to become a meticulous inventory specialist. And more than that, a mind reader trying to divine the testator's true intention. When a farm or a house was bequeathed as instructus, it meant fully equipped. But What on earth does fully equipped mean for a specific Roman household?
Right. Did it include the furniture, the slaves, the silverware?
Exactly. And the jurists had specific rulings, often debated. We know that a fully equipped Haus Domus Instructa would typically include things like, well, an antidote the owner kept there for visitors, any medicine stored there, even clothing deposited specifically at that location.
Practical stuff.
And slaves who worked only in the house, doorkeepers, gardeners assigned to the house grounds, valets, water carriers, they were usually included as essential equipment for the running of that specific property.
Okay, that makes sense for the necessities. But what about, say, luxury items? Or things like books? Intellectual property wasn't really a thing, but books were valuable.
That caused vigorous debate. The digest tells us explicitly there was a split opinion on things like fancy ivory tables and libraries of scrolls. One view excluded them, arguing they were purely personal effects of the owner, not equipment for the house.
But there was another view.
Yes, and apparently the better view, according to the jurists compiling the digest, included these items if, and this is the key, if they were used to equip the household head in his function or lifestyle within that house. So the definition hinged not just on the object itself, but on its designated role and use within that specific household's operation and status.
So the jurists are trying to reconstruct the testator's life, looking for the overall pattern to clarify the will's ambiguous terms.
Absolutely.
Yeah.
You see this search for intent in a famous observation by the jurist Papinian. He noted that if a testator, in bequeathing a house instructa, specifically took the trouble to exclude the silver plate and the account books from the legacy,
Then that implies.
it strongly implies he must have intended to include everything else physically present in the house. Otherwise, why bother listing just those specific exclusions? It's a process of negative inference.
Clever. But then imagine the challenge for the judge when, say, a wealthy merchant or a moneylender bequeathed his house as instructa to his sons. Did that bequest automatically include all the valuable merchandise or the pledges held as collateral that he kept stored in that house for his business?
Exactly. That forced the judge into a really difficult analysis. They'd have to compare the contents of that house with the father's other known business properties or warehouses. Was this house intended primarily as a place of business? Or was it just his residence, which happened to have some business items in it? The testator's overall pattern of life and business was crucial.
This incredible Roman focus on, well, legal formality, structure, minute details, it really stands in stark relief when we circle back to the Athenian approach to conflict. And here's where it gets, as you said earlier, really interesting. When property disputes or personal offenses became intensely personal, how did these different societies use the legal process itself as a weapon?
Well, in Athens, as we touched on, the courts frequently became these open forums for pure, raw, private animosity, just airing personal grievances in public. The most famous example has to be the legendary bitter rivalry between Demosthenes and Aeschines, two of the greatest orators ever, constantly at each other's throats.
And Demosthenes accused Aeschines of misusing the courts.
Flagrantly misusing them, according to Demosthenes. He accused Aeschines of turning what should have been serious charges related to state affairs into mere exercises in personal abuse. Slinging mud. The Greeks had a word for it. Loidoria. Just invective.
So for Aeschines, the trial wasn't just about defending himself against the actual charges. It was a platform to escalate the feud using the legal machinery itself.
Precisely. And crucially, the legal judgment in Athens wasn't always seen as a definitive binding end to the conflict. Often the legal process was deliberately used as a weapon, a tool, specifically to intensify the existing enmity.
And it pulled other people in.
Oh yeah. It wasn't just between the two main litigants. It drew in third parties, friends, neighbors, political allies, all taking sides, lining up through solidarity. Athenian litigants became masters of manipulating the community's normative expectations. They tried to convince the jury that they, as honorable persons, simply deserved to prevail almost regardless of the strict legal facts of the case. The trial became fundamentally a character assessment. Who's the better guy?
Okay, now contrast that culture, public shaming, character assassination, using the court as a stage for personal drama with the highly formalized Roman recourse that was available for things like duress and fraud. Roman mechanisms seemed aimed much more at just neutralizing the illegal act and restoring order.
Yeah, much so. Romans had specific formal legal actions designed precisely for recovering property lost or debt released under duress. Whether that duress was physical violence or extreme fear or intimidation, meet us.
And the remedy could be harsh.
Potentially, yes. If you were compelled, say, forced, to give a formal release for a debt someone owed you. The legal action available to you, the actio arbitraria based on duress, was for recovery of fourfold the amount.
Fourfold. That sounds terrifyingly punitive. Why such a massive penalty? Was it just pure punishment?
It was certainly intended to be terrifying, yes, a strong deterrent. But, and this is typically Roman, it came with a built-in release valve, a way out. The fourfold penalty was only actually exacted if the defendant refused to make restitution first.
Oh.
The praetor, the magistrate overseeing the case, essentially offered the defendant leniency. They could simply restore the property that was taken or cancel the release that was coerced and thus avoid the massive fourfold penalty entirely. It was designed to strongly incentivize immediate self-correction, make things right, and avoid the hammer.
So the penalty becomes less about abstract punishment and more about forcing practical compliance, getting the situation fixed. Now, what was that really unique thing about the burden of proof in this action for duress?
This is a fascinating detail and quite surprising legally. The plaintiff, the person claiming they were coerced, did not actually need to prove who specifically used the duress or committed the fraud against them.
Really? How could that work?
It was sufficient for the plaintiff to prove two things. One, that duress actually occurred, resulting in their loss of property or their releasing a debt, and two, that the person they were currently suing had benefited from that illegal transaction. The law focused intensely on the illicit result and the unjust gain, shifting the focus away from necessarily identifying the exact perpetrator of the initial coercion. If you benefited, you were potentially liable.
Interesting. The law also had to draw these fine lines regarding physical violence itself and insult, what they called injuria. Where did Roman law place the boundary for justifiable force versus unlawful violence?
They were actually very clear on the principles, even if the application could be tricky. Killing someone who is actively trying to attack you with a sword, that's lawful self-defense, no question. However, the law drew the line when the force used became excessive or clearly unnecessary in the circumstances.
For example.
The classic example given is killing a common thief. If the thief was running away, or if he could have been easily overpowered and arrested, killing him then was deemed unlawful. And injuria in the sense of an illegal, wrongful act causing harm. The law demanded that citizens use the minimum necessary force and specifically avoid killing if simple restraint was a viable option.
Proportionality, essentially. Now, what about the formal action for insult, the actio injuriorum? What legally constituted an insult, and how did the victim have to react at the time to maintain their standing to sue later?
The action for insult was explicitly founded on what was considered bonum et equum, good and equitable. And the critical factor here was a concept called dissimulatio, dissimulation, basically ignoring it.
Ignoring the insult.
Yes. The action for insult would fail, completely collapse, if the victim clearly ignored the affront when it happened, and then, maybe days or weeks later, tried to revive it and bring a lawsuit.
Why?
Because if you let the affront pass in the moment, if you didn't direct your mind to it, didn't react immediately, the court viewed that inaction as a form of acceptance, or at least a decision not to treat it as a serious injury to your honor at that time. And the equitable nature of the action meant you couldn't just legally revive the affront on second thought when it suited you, you had to act promptly.
Wow, that's a powerful societal demand baked into the law. You must respond immediately, publicly to defend your honor, or you essentially forfeit your legal standing to complain about it later.
Precisely. Your reaction or lack thereof had immediate legal consequences. And unsurprisingly, this was amplified by social status.
Yeah.
We see these incredibly nuanced, specific rules governing the relationship between a patron and their freedman when it came to insult. A freedman generally could not bring an action for insult against his own patron. Full stop. This reflected the patron's significant residual authority, which the law recognized as allowing for what might be termed reasonable chastisement or correction without legal recourse for the freedman.
So the power imbalance was explicitly coded into the law of insult. Was there ever an exception? Could the patron's actions ever be challenged as insult?
Yes, but a very specific telling exception. The husband of a freed woman could sue her patron for insulting her. This provided a kind of external layer of protection for the woman's dignity, mediated through her husband.
There's always an unless in Roman law, it seems.
Almost always. Unless that husband was himself a fellow freedman of the very same patron. In that specific case, the patron's overriding authority over both freed persons remained supreme, and the husband couldn't sue.
That subtle distinction just perfectly illustrates how deeply entrenched and how meticulously legally managed that whole power hierarchy was. Incredible. Now, these rules, these distinctions, they can seem quite academic when we just discuss them. But the surviving records, things like papyri from Egypt, show that this legal complexity was being applied to real, messy, often violent, high stakes family drama, right?
Oh, absolutely. We see this powerful, sometimes heartbreaking link between the formal law and utter domestic chaos in late antique petitions recovered from the sands of Roman Egypt. Consider the plea recorded from Aurelius Acis. She describes herself as a weak widowed woman.
Okay.
She explicitly petitions the authorities because, she says, her own full brother and his wife violently attacked her, pushing her to the ground, hitting her with blows, punches, kicks, tearing her clothing. She's petitioning because she cannot be passive about this grievous injury, especially from her own kin. She's seeking formal legal intervention to be avenged, to get justice.
That's just devastating evidence of domestic violence, requiring the intervention of external legal authority, even within the family.
It is. And another petition highlights the intersection of violence, not just with family, but with property and civic or religious status. We have a petitioner complaining that another person stole a libation that's a property dispute involving a religious item. Then, ruined an annual public procession that's a civic and religious offense, and physically assaulted the petitioner,
Tearing his clothes.
specifically tearing the special garment the petitioner wore for a particular religious office he held, that of terraphorus. The violence wasn't just physical, it was amplified because it directly undermined his public status, his religious role, his honor connected to that office. It shows just how inextricably property rights, personal offense, violence, and religious or civic roles were all woven together in the legal fabric of their lives.
Okay, if we pull back now, try to look at the broader philosophical, maybe ethical implications of all this, we see that the ancients, both in Athens and Rome, were really deeply engaged with this fundamental tension, weren't they? Between individual ambition, the drive to succeed, and the necessity of the rule of law.
Yes, absolutely. Cicero captured this conflict beautifully, I think, in his work on Duties de Officiis. He issued this really strong warning. He said that an elevated, ambitious spirit, the very kind of spirit you might think is required for great public service, for leadership, that kind of spirit can easily be corrupted
Corrupted by what?
by obstinacy,
Mhm.
stubbornness, and by an excessive, almost blinding longing for preeminence, the desire to be number one above everyone else.
And how does that intense longing, that desire to be the best, how does that undermine the pursuit of justice, according to Cicero?
Well, Cicero argues that it becomes incredibly difficult, maybe impossible, to sustain equity, fairness, the key characteristic of justice, when a person is driven solely by this fervent desire to best everyone else.
Mhm.
This kind of ambition, he says, inevitably leads such spirits to introduce bribery, factionalism, political turmoil into the commonwealth,
Why?
because they come to prefer achieving superiority through force or through manipulation or sheer factional power,
Hmm.
rather than achieving equality through justice. They value winning over fairness.
So for Cicero, true courage isn't about aggression or dominance. It's defined more by restraint.
Exactly. For Cicero, true courage, true magnanimity, resides in those who repel injury, those who protect the community and uphold the law, not in those who cause injury in their relentless pursuit of personal dominance. The truly great spirit, he concluded, prefers to be preeminent through actual virtue and service, rather than merely to seem preeminent through manipulating popular acclaim or using brute force. A crucial distinction.
A very relevant distinction, perhaps. But that philosophical pursuit of virtue, that ideal, it had to contend with the messy realities of political life, especially in Athens, where, as we've discussed, the rule of law was so tightly interwoven with democratic power.
That's right. In Athens, the rule of law, isonomia, was often seen, practically speaking, as serving the collective interests of the demos, the popular assembly, as interpreted by the popular courts. Now, we know Athenians deeply valued legality and principle. They strongly criticized, for instance, the 30 tyrants.
The oligarchic coup after the Peloponnesian War.
Right. They slammed the 30 for violating the rule of law by arresting and executing men without proper trial, purely according to personal whim. So they clearly affirmed their commitment to establish legal process, to not being subject to arbitrary power.
Yet, as we established earlier, that same commitment to democracy and legality still allowed for this massive, messy space for personal feud, character attacks, and rhetorical manipulation right inside the courtroom.
And that's the persistent tension, isn't it? The radical democratic notion in Athens seemed to be that, while yes, no individual citizen stood above the law, the courts themselves often permitted practices like those endless character assassinations, the playing on jurors' emotions, the bringing in of totally irrelevant personal history practices that most modern legal systems would view as completely extraneous and prejudicial.
And they allowed it. Why? Because it served the perceived interests of the demos.
It seems so. They allowed it because the rule of law itself was just inextricably tied to the court's perception of the political interests, the social norms, and the collective will of the popular assembly that constituted the jury. Justice was what the demos decided it was in that specific case.
Okay, let's bring it full circle now, back to the Roman foundation one last time and their intense focus on legal practicalities.
Hmm.
We've seen the incredible complexity they built into inheritance law through centuries of jurisprudence, culminating in the Digest. What about the very earliest Roman legal foundation? Does it show that same practical bent?
Absolutely. If we go way back, return to the very bedrock of Roman jurisprudence, the Law of the 12 Tables, to the mid-5th century BC, we find that same focus on structured process, especially in basic economic interactions like creditor-debtor relations.
For example,
Well, one famous provision from the tables granted a debtor who had been formally judged liable for something in court a mandatory delay, 30 days grace period before the creditor could take any further enforcement action against them, like seizure of property or personal bondage. It underscores the system's initial commitment right from the start to highly regulated, structured, step-by-step interactions. Process was key.
and finally, just to tie off the inheritance theme, what was the judge's critical duty when it came to actually dividing up an inheritance among multiple co-heirs, especially if the will gave preferential treatment to one?
Right, the iudex familiae ursiscundae, the judge for dividing the family inheritance. In those complex cases, the judge had to carefully synthesize the will's potentially complicated instructions with a sense of overall fairness among the co-heirs. Specifically, one key duty was to ensure that the general group of co-heirs did not improperly exact payment or contribution from one particular heir who had received, through the will, a preferential claim like being assigned specific debts owed to the deceased before the general division.
So the judge had to make sure that preference was fully honored first.
Exactly. The judge was tasked with ensuring that any such preferential claim, stipulated clearly in the will, was honored first, satisfied in full, before the remaining assets were pooled, and the other co-heirs could demand their proportional share of the overall division. It was about respecting the testator's specific wishes while managing the distribution equitably among all beneficiaries. Hashtag outre.
Well, this has certainly been an intensive deep dive. We started out acknowledging, the famous criminal drama of the ancient world, the big trials. But what we've really uncovered today is that the true legal engine, the place where Roman legal ingenuity arguably shone brightest, or at least worked hardest, was in managing these intensely personal, incredibly high-stakes family and property conflicts.
Yeah, the Romans built just layer upon layer of detailed protection and process. From concepts like agnation to ensure crystal clear lineage for property transfer, to the pragmatic brilliance of the lex falsitia, ensuring the whole system didn't collapse under its own weight, and these very specific formal actions like the actio arbitraria, designed to precisely neutralize illegal acts like duress.
And all that stands in such sharp contrast to the Athenians, who seem to use their legal system almost as this volatile public forum where personal enmity, political grudges could be fiercely prosecuted right under the guise of seeking justice, forcing litigants into becoming masters of manipulating community expectations and character assassination.
So hopefully you, our listener, now possess the fundamental scaffolding, the basic framework necessary to really understand how property, kinship, and the disputes arising from them truly functioned in these incredibly intricate ancient societies. It wasn't just abstract law. It was applied to the most bitter domestic dramas imaginable.
Okay, and as always, we like to leave you with a final provocative thought to chew on. Here it is. We've seen today that in a legal system as vast, as detailed, as incredibly nuanced as Rome's, knowledge itself, or maybe more accurately, the meticulous interpretation and correct application of these dense legal texts became the ultimate weapon, or at least the ultimate tool. So, given the enormous complexity we've discussed just in inheritance law, all those rules about conditional heirs, calculating the lex falsitia requiring precise valuation at the exact moment of death, the need to inventory every single item down to the ivory tables and medicines to figure out what fundus instructus even meant. Just imagine the professional world that must have existed around this.
Yeah, not just the famous orators arguing the big cases.
Exactly. Think of the countless, probably quite unglamorous legal secretaries, clerks, archivists, record keepers, the paralegals of their day. With such a crushing volume of nuanced, detailed, sometimes even contradictory rules to keep track of, here's the question. Was the noble pursuit of abstract justice sometimes inevitably superseded by the sheer grinding necessity of mere administrative competence? Did just navigating the information overload become the primary challenge, perhaps even overshadowing fairness?
That is definitely something to ponder. Was the system just too complex for its own good sometimes?
We'll leave that question hanging in the forum air. Until next time on The Deep Dive.
Thanks for joining us.